What you know, alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Tuesday, December 23rd. I was planning to get an episode in yesterday, but I underestimated the amount of traffic and people that would be out Christmas shopping and got caught up in that hoopla. But we are going to keep going today on this state's response to Lori Daybell's filing for her appeal. When we left off, the state was saying that Mark Means had the opportunity to file a response to the state's motion. He just chose not to do so. Vallow has failed to prove her constitutional right to counsel was violated. I remember when this happened, this was a pretty big deal, and Mark Means went on Twitter, complained about being kicked off the case. And I remember thinking, this is going to take forever for her to go to trial with a new defense counsel coming in. They have to catch up. Seems like forever ago. All right, so the next section, Vallow has failed to show any error plainly exists in the record. The second prong of the fundamental error test requires Vallow to show the alleged error plainly exists. They cite a case called Perry. Demonstrating an error plainly exists requires a showing that the error is clear as a factual matter, without the need for any additional information not contained in the appellate record, including information as to whether the failure was to object was a tactical decision. Vallow has not shown the error plainly exists. Her alleged constitutional claim is that the district court violated her right to counsel by excluding Means from arguing the state's motion to disqualify in a separate criminal proceeding. But, as explained above, Means had the opportunity to file a response to the state's argument in his client's criminal proceeding, but failed to do so for reasons that are anything but plain in the record. Determining Means' motivation and intent is factual in nature and thus more appropriately addressed via a petition for post-conviction relief. And they cite State v. Miller. Presumably, Vallow will respond that Means did not file a response to the state's motion because the court had stayed the case pending Vallow's restoration to competency. But that is the kind of inferential leap that cannot satisfy the second prong of fundamental error, especially given the numerous documents Means filed in the Vallow case during the same time frame. Vallow cites Means' motion to intervene as proof that Means did not make a tactical decision when he failed to raise the Sixth Amendment claim. And they're citing State versus Bodenbach. Her reliance on Bodenbach is misplaced. In Bodenbach, the Idaho Supreme Court found the second prong of fundamental error satisfied because the defense attorney had objected to the challenged jury instruction on a different basis. The court concluded the failure to raise a constitutional objection could not have been tactical because defense tried to stop the instruction from being given at all. The court's implied logic, of course, was that defense counsel would not tactically refrain from making a constitutional argument that would have had the same result as defense counsel's non-constitutional objection. The Bodenbach logic does not apply here. The district court expressly stated that it did not interpret Means' motion to intervene as a request to be heard, and they're citing State versus Daybell. Yet Vallow's appellate claim is that the district court violated her Sixth Amendment right to counsel by refusing to hear from Means. Thus, Means' motion to intervene does not serve the same purpose as defense counsel's objection in Bodenbach, and Vallow is still left without evidence in the record showing any error plainly exists. Next section, Vallow has failed to show any error was not harmless. Vallow has failed to satisfy the third prong of the Perry fundamental error test. The third prong of the Perry fundamental error test requires Vallow to show the alleged error was not harmless. Vallow claims she need not offer any proof in the record on this prong because the complete deprivation of counsel is structural error and prejudice is presumed. She is correct that the complete deprivation of counsel is structural error, but the partial deprivation of counsel is not, and it says see Satterwhite versus Texas. Explaining the deprivation of counsel is structural error only where it affected and contaminated the entire criminal proceeding. And it says, see Russian versus Spain. Explaining counsel's absence from ex parte communication between judge and juror was subject to harmless error review. They cite U.S. versus Morrison, holding counsel's absence during return of verdict subject to harmless error review, and Vines versus the U.S., holding counsel's absence during trial subject to harmless error review because no evidence directly inculpating defendant was presented while defense counsel was absent. The error Vallow alleges is subject to harmless error review because she was not completely deprived of counsel during the hearings. The record shows that Vallow was represented by 2 attorneys during the period she now claims total deprivation of counsel. Means was present during both hearings, and Archibald was present during the first and much of the second. In a footnote, it says Vallow asserts deprivation of counsel because Means could not participate in the hearing where the district court inquired of Daybell alone with his counsel. But that was intentionally an ex parte hearing to protect Daybell's Fifth Amendment rights. Even if the district court had granted Means' motion to intervene, he would not have been allowed to participate in that hearing. Most importantly, as Vallow concedes, the hearings were focused on Chad's rights to conflict-free counsel rather than Lori's right to counsel of her choice. Means' inability to participate in a hearing focused on a different criminal defendant's constitutional rights, even as a co-conspirator, does not constitute the complete deprivation of counsel required for structural error, especially where he had the opportunity to file a response in his client's case. In an effort to show prejudice, Vallow throws out several possibilities of how the hearing might have been different if Means participated. None of them satisfy the third prong of fundamental error because none of them are based on evidence in the record. For example, Vallow claims the proceeding would have been different because Means would have shared his version of events, but she fails to point to any specific facts in the record that Means would have shared at the hearing, much less explain how those facts would have affected the proceedings. Also, Vallow claims Means could have impressed upon the court the importance of Ms. Daybell's right to counsel of choice, which seemed to get overlooked in the process. But Vallow's right to counsel of choice did not get overlooked at the hearings. The parties and the district court intentionally focused on Daybell's rights at the hearing because they were hearings in Daybell's case. And they quote State versus Daybell, "This isn't about Lori. Chad Daybell has independent rights to not have a former attorney in an adversarial position against him." End quote. The district court's written decision disqualifying Means analyzed Vallow's right to counsel of choice at length, and Vallow has failed to explain what else Means would have said about the right that would have affected the proceedings. Vallow has thus failed to show any error was not harmless. The next section, Vallow has failed to show the district court committed fundamental error by violating her due process right not to be prosecuted or to be physically present at proceedings. Introduction. Vallow has failed to show fundamental error in the district court's decision to hold hearings in Daybell's separate criminal case while Vallow was incompetent. Neither Vallow's right not to be prosecuted nor her right to be physically present applied to proceedings in a separate criminal case. Moreover, the unique procedural circumstances of this case placed the district court in between multiple constitutional rights belonging to Vallow, who was at the time incompetent. The district court's decisions reflect that it protected, not violated, Vallow's constitutional rights. That is not fundamental error. The next section is standard of review. Alleged constitutional errors during trial that are not followed by a contemporaneous objection must be reviewed under the fundamental error doctrine. And it says, see State versus Medina. Next section, the district court did not commit fundamental error by holding a hearing in a separate criminal proceeding without the then incompetent Vallow. The district court's decision to hold a hearing in Daybell's separate criminal case without Vallow present and, while she was incompetent, did not constitute fundamental error. To prove fundamental error, Vallow must show that the alleged error, 1, violated an unwaived constitutional right, 2, plainly exists, and 3, was not harmless. She cannot satisfy her burden on any prong. Number 1, the district court's decision to hold a hearing in a different criminal proceeding while Vallow was incompetent did not violate her constitutional rights. Vallow asserts the district court violated 2 of her unwaived constitutional rights when it held hearings in the Daybell case while she was deemed incompetent. She is wrong on both counts. Vallow first contends that the district court violated her right not to be prosecuted while incompetent. The due process right to a fair trial encompasses a right not to be tried or convicted while incompetent to stand trial. They cite Drop versus Missouri. The same standard applies to those who plead guilty. Then it says, see Godinez versus Moran. A state's statutory procedure for determining an accused mental capacity to stand trial is constitutionally adequate to protect a defendant's due right process right not to be tried while legally incompetent. And they cite State versus Lovelace. In Idaho, this right is protected by Idaho Code 18-210 through 18-212. Pursuant to these statutes, no person who has a result of mental disease or defect lacks capacity to understand the proceedings against him or to assist in his own defense shall be tried, convicted, sentenced, or punished for the commission of an offense so long as such incapacity endures. If the court determines the defendant lacks fitness to proceed, the proceeding against him shall be suspended except for further proceedings related to the defendant's competency or if the defendant escapes from custody. The case law in Idaho explaining this suspension is sparse, but suggests the obligation to suspend proceedings would apply at least as early as a preliminary hearing. See Lovelace. Rejecting claim that magistrate failed to suspend proceedings at preliminary hearing because requirements for suspension not met. The district court properly suspended the proceedings in Vallow's case. On May 27, 2021, prior to finding Vallow was in fact incompetent to proceed to trial, the district court entered an order staying Vallow's case because of the issue of defendant's competency. Then, on June 9, 2021, the district court entered an order finding Vallow was not competent to proceed and suspended the case except as provided in Idaho Code. The suspension was not lifted until the district court found Vallow's competency was restored on April 11, 2022. Vallow contends the district court violated the suspension of proceedings by holding several hearings while Vallow was incompetent. But the hearings she cites were all held in a separate criminal case against Daybell. The district court went out of its way to clarify that the proceedings Vallow now cites were not happening in the Vallow case because of the stay. And they cite from State versus Daybell, but right now, case 1624 is stayed, and we're only having a hearing on case 1623 as a result. And again, quote, as I think everyone's aware, Vallow's case is currently stayed pending a determination that Vallow be found competent to proceed, end quote. Vallow's constitutional right to not be trialed while incompetent did not require the district court to suspend a separate criminal case. If the court determines that the defendant lacks fitness to proceed, the proceedings against him shall be suspended. Furthermore, the district court's entry of an order disqualifying means in Vallow's case while Vallow was incompetent did not violate this right. In a footnote, it says the state reads Vallow's opening brief to argue only that the hearings violated Vallow's due process right, and she has thus waived the argument that the entry of the order did so as well. They cite Gallagher versus State, holding that when an appellant fails to support an issue in the opening brief with law, authority, or argument, that issue has been waived and cannot be revived in the reply brief. However, the state covers the issue out of an abundance of caution. The same argument would apply to the hearings if this court were to determine that the hearings were somehow part of Vallow's case. Neither the U.S. Supreme Court nor Idaho's appellate courts have clearly defined the suspension of proceedings that due process requires upon a finding of incompetency. But we know, for example, that not all proceedings are halted because certain proceedings necessarily must move forward. They cite Idaho law suspending proceedings except for further competency proceedings and when the defendant escapes custody. We know that constitutional rights are less rigid than Vallow suggests, at least when placed in competition with other constitutional rights. They cite Indiana versus Edwards, holding constitutional right to represent oneself must yield to the constitutional right not to be tried while incompetent when a state insists that a borderline competent individual must be represented at trial, or the fundamental fairness of the proceedings, and they cite Wheat versus the U.S. Holding trial court can reject defendant's waiver of a conflict counsel in part because courts have an independent interest in ensuring that criminal trials are conducted within the ethical standards of the profession and that legal proceedings appear fair to all who observe them. The district court's actions in this case respected, rather than violated, Vallow's constitutional rights. The court found itself in an unbelievable position when Vallow's right to the effective assistance of counsel, otherwise conflict-free counsel, and her right not to be tried while incompetent means not only had a conflict or the serious potential for a conflict, but he continued to take actions on Vallow's behalf despite the district court's order suspending the proceedings. Means actions were both serious, filing motions to dismiss the indictment and to change venue in Vallow's capital case, and seriously concerning, such as making himself a witness to the proceeding and apparently violating attorney-client confidences of an incompetent client. It means actions necessarily could not have been knowingly authorized by Vallow given her incompetence. If the district court waited to disqualify Means, it would do so at the cost of Vallow's right to conflict-free representation in a capital proceeding, not to mention its own independent interest in ensuring that legal proceedings appear fair to all who observe them. Recognizing that it had a duty to protect her rights while Vallow remained incompetent, the district court correctly acted and disqualified Means. Notably, the district court's decision left the door open for Vallow to raise any concerns with the process after she was restored to competency. And they quote, "If and when Vallow is restored to competency, the court could conduct an inquiry into her interest in waiving qualified counsel. However, until such time, this court's duty to protect her rights remains." Neither she nor her counsel did so. The district court's actions in this case protected Vallow's right to conflict-free counsel while also preserving her right not to be prosecuted while incompetent. Vallow next argues the district court violated her rights to be present by conducting the hearings in the Daybell case while she was incompetent. Separate from the Sixth Amendment right to confront witnesses, a criminal defendant has a due process right to be present in his own person whenever his presence has a relation reasonably substantial to the fullness of his opportunity to defend against the charge. They cite State versus Dunlap and quoting Kentucky versus Stenser. But the defendant does not have a right to appear when presence would be useless or the benefit but a shadow. A defendant claiming his absence from a hearing constituted a due process violation has the burden of showing that he would have gained anything by attending. They cite U.S. versus Gagnon. Holding defendant failed to show constitutional violation because he has not shown how his presence could have affected the outcome of either hearing. See also Clark versus Chappelle. In Clark, the defendant claimed his due process right to be present had been violated when the district court held a meeting to discuss the defendant's counsel's potential conflict outside of the defendant's presence. He claimed if he were present at the meetings about his counsel's conflict, he would have insisted on a full hearing and removal of counsel. The Ninth Circuit rejected his argument. Quoting, "The discussions at this meeting were later described by defense counsel in open court for the trial judge in the defendant's presence, and the defendant made no objections or requests for a further hearing. Thus, the court found the defendant's constitutional claim failed because he had not shown that he would have gained anything by attending. Vallow's claim fails for more reasons than the defendant's claims in Clark. First, as explained above, the hearings Vallow now claims she wanted to attend were held in a separate criminal case. Neither the U.S. Supreme Court nor Idaho's appellate courts have held that a defendant has a due process right to be physically present in hearings held in someone else's criminal case. Second, Vallow was incompetent at the time of the hearings. By definition, Vallow's presence would be useless or the benefit but a shadow, and that's quoting Stenser, because it's uncontested that she lacked the capacity to understand the proceedings against her or to assist in her own defense. So just a reminder, when you are deemed incompetent, one of the biggest things is you cannot assist in your defense. So her argument really falls very short. And I also see the big issue with Means filing things even though she was incompetent, because everything should have halted. So that's really the gist of all this. Third, even setting aside the issue of competency, Vallow's presence would have been useless because the district court properly found the conflict created by Means' dual representation could not be waived. And they cite People versus Jean-Baptiste. Finding defendant's presence was not required at hearing on his counsel's disqualification, since defense counsel could not have continued to represent the defendant under the circumstances of this case. Therefore, Vallow's presence was not constitutionally required. Fourth, like the defendant in Clark, Vallow has not shown that she would have gained anything by attending. She did not even try. And they're quoting Gagnon, arguing under the first prong of Perry only that she could not have waived her right to be present. Whatever Vallow comes up with in her reply brief is insufficient because, like the defendant in Clark, she did not present that request, argument, or fact to the district court. Rejecting same constitutional claim where defendant was made aware of proceedings in his absence. Rejecting same constitutional claim where defendant was made aware of proceedings in his absence and had made no objections or requests when he became aware of the proceedings. Vallow failed to present any such argument or additional facts, even though the district court at least implicitly invited Vallow to raise the issue again upon her restoration to competency. And they quote, "If and when Vallow is restored to competency, the court could conduct an inquiry into her interest in waiving qualified counsel. Vallow has thus failed to prove she had a due process right to be present at the hearings held in the Daybell case." The next section, Vallow has failed to show any error plainly exists in the record. The second prong of the fundamental error test requires Vallow to show the alleged errors plainly exist, and they cite Perry. Demonstrating an error plainly exists requires a showing that the error is clear as a factual matter, without the need for any additional information not contained in the appellate record, including information as to whether the failure to object was a tactical decision. Vallow cannot do so on either of these constitutional claims. Vallow has failed to show that any error plainly exists with respect to her right not to be prosecuted while incompetent. Means' motion to intervene at least strongly implied that he was trying to intervene for the purpose of arguing the conflict on the merits. And they quote, "Intervention request is timely and appropriate for this matter to present to the court facts and events necessary to determine said motion." Then at the hearings, he seemed to suggest he wanted to object to moving forward in the hearings at all because of the stay. But, as explained above, Means still continued to file and take actions in Vallow's case. Thus, Means could have made a tactical decision not to raise the constitutional objection because he wanted to be able to keep filing motions and taking actions in his client's case. Vallow has also failed to show that any error plainly exists with respect to her right to be physically present at the proceedings. All she cites in her brief to meet her burden on this claim is that 1, she was physically absent from the hearing, and 2, that Means stated in his oral argument on the motion to intervene that he was objecting to the hearing proceeding. Neither of those facts imply, much less prove, that Means did not make a tactical decision on the issue of Vallow's physical presence at the hearing. Means did not say anything about Vallow being present at the hearing, and he did not make any effort prior to the hearing to arrange for her presence. If anything, the more reasonable inference from the current record is that Means made the tactical decision to forego Vallow's physical presence because she was deemed incompetent. They cite State versus Alvarado. The evidence Vallow cites in the record does not show the alleged error plainly exists. The next section, Vallow has failed to show any error was not harmless. Vallow has failed to satisfy the third prong of the Perry fundamental error test. The third prong requires Vallow to show the alleged errors were not harmless. Vallow attempts to short-circuit this prong by asking this court to assume prejudice. Unfortunately for Vallow, that is not the law. Structural errors, where the error is assumed to be prejudicial, are the exception and not the rule. They cite Rose versus Clark. The Supreme Court has never held that the exclusion of a defendant from a critical stage of his criminal proceedings constitutes a structural error. And then Campbell versus Rice, On the contrary, the court has explained the right to be present during all critical stages of the proceedings, as with most constitutional rights, is subject to harmless error analysis, unless the deprivation by its very nature cannot be harmless. They cite Russian versus Spain. Subsequently, courts have found that violations of these rights are generally subject to harmless error analysis. They cite Bourne versus Curtin. This includes at a hearing where the court discussed a potential conflict with defendant's counsel. They cite Rice versus Wood, holding error subject to harmless error review where defendant was absent when jury sentenced him to death. Harmless error analysis makes sense when the defendant has been erroneously excluded from a hearing because the error can be assessed in order to determine whether or not it was harmless. The hearings in this case are no different. One could readily determine whether Vallow's absence from the hearings had any effect on those hearings by determining what information Vallow could have provided to the court or what action she could have taken during the hearings, and then decide whether that information or action would have actually affected the outcome of the proceedings. This might require the development of new facts after the hearings, but that does not make the error structural, quite the opposite. And it says, see Russian. Defendant's absence from conversation between judge and juror is subject to harmless error analysis because effect of supposed error can normally be determined by a post-trial hearing. The effect Vallow's absence had is therefore only unknowable on this record, meaning Vallow cannot satisfy the third prong of fundamental error, and the matter would be better handled in post-conviction proceedings. So we're going to end it there because then we get into a whole new argument. I'm hoping to have that out today and finish this up. You know, for me, this is interesting because there was a lot of stuff that was under seal during her incompetency. We just didn't know anything about what was going on behind the scenes. I love reading appellate briefs and the responses to those. A lot of times you throw a lot of stuff against the wall and hope something sticks, but not at all worried that anything in here is going to affect her conviction in Idaho. And we'll have appeals out of Arizona as well. So these appeals will go on for quite a while. And with Chad's, because it's a death penalty case, it's going to take a lot longer. But we haven't heard the last of these two yet. So that is it for now. I hope you guys have a good rest of your afternoon, and we will see you soon.